Thank you. This is a judgment by my sister, Hughes J.A. and Nuicha Huasen, Molefe JJA, Kubushi and Klute AJA have concurred. And I just read the final paragraph of the judgment, which reads as follows. In the result, the following order is made. 1. Safe to the extent set out below, the appeal is dismissed. And 2. The order of the High Court is amended by the deletion of paragraph 7 and 8 thereof and the substitution of paragraph 9 with the following, and quote 9. The first respondent is ordered to complete the relocation of the second respondent within 1 year of the date of this judgment. And then 3, the first appellant is ordered to pay the costs. Just a correction, this is Molefe's JA's judgment and the other justices concurred in it. I hand the judgment down accordingly.
Lungu and others against the Republic of Zambia and others, case number 089.
May it please the court, I appear together with Mr. Kwabe for the appellants.
Thank you, Mr. Ngukatobe.
May it please the court, I appear on behalf of the first respondent with Malena Jr. and Marcus.
Yes, thank you, Mr. Ngukatobe. Before you start, there is the issue of the condemnation. Yes. For the late filing of the heads and the reinstatement of the appeal. Yes. My understanding is that there's no objection. Mr. Stoop, can you just confirm?
I confirm.
Very well. Condemnation is then granted as prayed for.
May it please.
Mr. Ngukatobe, you as discussed in chambers, you have elected to take advantage of your 10 minutes immunity, which will start now. It's almost... well, that watch in the back is something wrong with it. Yeah. It's about just over 1:45 now, so we'll let you know when you get closer to your 10 minutes.
May it please you.
I think that one is more correct.
That one's better.
Oh, yeah.
Okay, all right.
Thank you.
Thank
Over
you.
to you, Mr.
Yes, thank you. The issue on appeal is whether the High Court was correct in concluding that the government of Zambia had established a clear right to the body of President Edgar Lungu. The pleaded basis for the clear right was the alleged contract as well as the provisions of the Benefits Act of Zambia. We submit that the High Court was wrong in concluding that the clear right had been established on either basis. My client, as the court knows, comprised the widow of the late president of Zambia, Mr. Lungu, his children, and his immediate family. Mr. Lungu died on South African soil on the 5th of June 2025. It is next week is in fact the first anniversary of his death. His body still remains at a mortuary in Pretoria because the dispute has dragged on and it is yet to be resolved. What we know about Mr. Lungu's own wishes appears at page 187, paragraph 3.34 of the answering affidavit. He did not want the current president of Zambia.
Mr. Toby, I'm not interrupting you. Just repeat that.
It's page 187,
Thank you.
paragraph 3.34. That's what we know about Mr. Lungu himself. He did not want the current president, Mr. Hichilema, to have anything to do with his body or his funeral. He told his confidant, Dr. Sishana, who is a lecturer at Stellenbosch University, that he does not wish for Mr. Hakainde Hichilema to have any role in his funeral. That's largely because by the time Mr. Lungu came to South Africa, there were deep-seated political and personal problems between him and the current government of Zambia. We also know that the wishes of the widow, Ms. Esther Lungu, my client, and the wishes of the children and the immediate family are that the current president of Zambia should have nothing to do with the body. We also know that the family does not want to be dictated upon by the Zambian government about where the body ought to be buried. If they elect to bury the body in South Africa, which is what they intended to do on the 17th of June, 2025, they do not want the Zambian government to interfere with that decision. If they elect to bury the body in Zambia, they also want that decision to be made by them. So the problem with the High Court's decision, the departure problem with the High Court's decision was that it did not adjudicate the constitutional rights that were pleaded by the family. And even its approach to the foreign law discussion was a mistaken approach because it did not do what this court recently held in the MTN case, which is you proceed from the premise of the South African Constitution. And we know this was pleaded expressly from page 170 of the pleadings at paragraph 2.3.1, 2.3.3, and page 203 at paragraph 13. So if the court below had approached this matter from the provisions of the South African Constitution, what it would have found is that the Bill of Rights in South Africa, and in fact the common law in South Africa, plainly allows the family the unquestionable right to decide what to do with the corpse of President Lungu. It would have found the source of that from the right to dignity, the right to family life, the right to equality, which were all pleaded in the paragraphs at 2.31 and 2.33. But because it failed to conduct a constitutional analysis, it misdirected itself and ultimately delivered a confused judgment. And confused is not an insult in this instance. It's confused because, on the one hand, it says that Zambian law applies, but in its interpretation and analysis of the alleged contract, it applies South African law. So it's a conceptual confusion. But there was no need for that conceptual confusion because South African law is clear on the point. Burial rights follow the law of succession. The law of succession on this point is clear. You first look at the wishes of the deceased. If you cannot ascertain the wishes of the deceased, the widow decides. The wishes of the deceased are known because they were pleaded. The wishes of the widow are also known because they were pleaded. There is just no basis whatsoever to override the wishes of the deceased and no basis to override the wishes of the widow. If we then look specifically at the alleged causes of action, we have two. The first one is the Benefits Act. If I could ask the court to have regard to volume 1, the Benefits Act is helpfully copied in full by the applicants So that act appears at page.
Page 123, Mr. Nkatobi.
One, two, three. Yes, correct. Thank you, my lord. It is at FAA 14. The relevant section that was cited by the government is at page 125, section 4, capital A. But that entire section does not give the right to the government of Zambia to the body or the corpse of Mr. Lungu. The same with the schedule, which is at page 127. Item 9 simply says that the funeral expenses will be paid for by the government of Zambia. But there is no right to take the body against the wishes of the widow from that act. So this particular cause of action could not confer the right on the government of Zambia to override the wishes of the widow. And then we look at the alleged contract. We submit that this contract was not established on the papers. And I think I want to spend some time on this because it is the confusion that lay through the judgment of the High Court. Number one, the High Court, the court will recall, used Annexure FAA 7 at page 92 as reflective of the agreement. Now, if you look at FAA 7, page 92, on its own terms, that is not an agreement. It is a proposed program for the funeral. But it is also not the pleaded agreement by the government of Zambia. The government of Zambia did not plead that FAA 7 was the agreement. What it pleaded was that the agreement was concluded after AA 7 was prepared. But FAA 7 also on its own terms does not give any role to Mr. Hakainde Hichilema, which is the main dispute between the parties, is what role should the current president play. So FAA 7 does not give the right to the government of Zambia to take the body against the wishes of the family. Then you look at the three annexures that are attached and are said to reflect the agreement. It's FAA 9 at page 94, FAA 10 at page 100, and FAA 11 at page 109. These are the recordings of the press conference that took place on the 15th of June, 2025. The recording that is common cause between the parties is the recording at FAA 10, page 100. And it is the press briefing given by Mr. Zulu, who is the spokesperson of the family. But in that press briefing, Mr. Zulu makes it clear at page 102, between line 10 and line 15, that the family and the widow specifically said, in the event that Mr. Lungu was accorded a state funeral, his successor should not be allowed to attend it. That's expressly stated. When he records the agreement at page 100, from line 20 onwards, and the following page 104, he again makes no provision for any role to be played by President Hichilema. You will see that at page 104, line 15 to 20, the only agreement or the only concession the family was willing to give was that the state funeral that will host dignitaries shall be held at Mulungushi Conference Center on Sunday, 22 June, and the body of former President Lungu shall be taken to the venue and returned to Chifwema after the event, where it will lie in state. The problem is that this agreement was not honored by the government of Zambia. It imposed President Hichilema on the program that the court will find annexed to the answering affidavit. There are 3 additional programs that the court will find. The first one is at page 258. It is part and parcel of Annexure EL 16. At page 258, the Zambian government inserted under Serial 2 the role of the President of Zambia. That was subsequently amended at EL 17, page 261 to 262, where his role was removed. And then his role was again inserted at EL 19, page 266 and 267, where his role is again reinserted. So what's clear is that the matter remained in dispute throughout, and the alleged agreement was simply never concluded, even on the pleaded facts. And the High Court regrettably misdirected itself on the evidence that was before it, and it latched upon FAA 7, when FAA 7, even on the applicant's version, was not the basis for the agreement. And when you analyze the 3 press conferences and the 4 different programs that were exchanged between the parties, it is abundantly clear that the role of Mr. Hichilema remained in dispute.
Mr. Lukatobi, I think your immunity is just ended. I just have to, and I think this is perhaps a good time for questions from the bench to be put to you. My understanding of Mrs. Lungu's case, insofar as the right entitlement under the Benefits Act is concerned, which has been asserted by the government, is that, and I think she says it in terms in the affidavit, is that at the time when Mr. Lungu passed away, he was an ordinary citizen, having been stripped of all his rights. And in response to that, the government then proffers the argument that, well, in terms of the Benefits Act, his benefits were not permanently withdrawn, but they were merely suspended. And in any event, at his death, his widow would have become entitled to certain benefits. And I think they tried to found the government's asserted entitlement to insist upon a state funeral on that basis. So I just want us to go to page 128 first. Page 128 is the letter. 128 is the letter. It's FAA 15. Now, and I'm putting this question to you. It's probably also a question that should be put to Mr. Stoop as well. But it's important to understand, and I'm asking you, what was left of Mr. late President Lungu's status as former president after this letter?
Well,
is there anything left after it?
No, the answer is no. Paragraph 5 is quite clear. Accordingly, Your Excellency, be informed that the government will enforce the law with immediate effect by withdrawing all of the benefits conferred on you by the Act. And although the pleadings, they now say today, they now say this was all temporary, but that's inconsistent with the letter that they sent, particularly paragraph 5. In fact, in the correspondence, there's nothing at all before the death that said there was ever an intention on the government of Zambia to reinstate these benefits. They then latch upon.
But in any event, I mean, does that matter? Is the fact of the matter not at the time when when the former president passed away, there was nothing?
Yes.
Even the vehicles, his office,
Yes.
support staff, everything
Yes.
was taken away. Now, with that in mind, let's just go to the benefits. The Benefits Act again. I think I gave
Yes.
it.
Well,
So
you found it earlier. Now it's my turn. 122.
122. 122. Thank you. The benefits which will endure upon the passing away of a former president is set out in subparagraph 2 of on page 125, 4A. And then it says, where a former president who is entitled to the benefits conferred under subsection 1 dies while in or after having left office, then it gives certain benefits that would endure. But was the former president entitled to those benefits at his death?
Yes. No, because they claim that they were withdrawn under section 5.
Yes. So at the time of his death, he had been stripped
Yes.
of the benefits, so he would not have been entitled.
Yes.
Which would then mean, effectively, that Mrs. Lungu could not have insisted as of right on a state funeral. Is that not so?
Yes. Yes. It would have been discretionary.
Where is the government's entitlement to insist of a state funeral is then founded in the Benefits Act?
I think the best we found for them is page 127, item 9, under the other benefits. So that's the best provision we could find for them that talks about a funeral. The rest of the act does not refer to a funeral at all.
Yes.
But in any event, if you have even if you have an entitlement to something,
Yes.
where does it give the corresponding?
Yeah.
I mean, it places a corresponding obligation
Yes.
on the state if you're entitled to that benefit.
Yes.
How
Yes.
does that benefit translate into an entitlement to the state?
Yes, and because funeral expenses, if the family decided to bury President Lungu in Soweto, one might say that the family may claim for those benefits and say you should pay for the funeral. But that doesn't give the right to the Zambian government to dictate where the bones of Mr. Lungu must be laid.
Yes. Sorry, just on this issue, I must maybe just ask my colleagues, have you any questions on this issue of the Benefits Act?
Oh yeah, maybe, yes. Maybe one question, Mr. Nketo. It is not the benefits that make a person a former president. Am
Yes.
I correct?
Yes,
He would have held his title, that
Yes.
is, was the 6th president of the Republic of Zambia,
yes,
and regardless of whether or not benefits were stripped.
yes,
Yes. And to that extent, which is how I think the government is linking it to it, if he was then a former president, he would have been entitled to a state funeral if they decided to accord him one.
yes.
Thank you.
Yes.
Then just on the issue of the agreement, as I understand Mrs. Lungu's case in terms of the averments made in the farming affidavit, she refers to, she says that, I understand it, that we could never have agreed, never had an intention to agree that the current president is going to play any role
Yes.
in the funeral.
Yes.
And she says that because she then based that on certain incidents. First of all,
Yes.
there was the church, the incident at the church,
Yes.
and then there was the incident where he was prevented from traveling to the conference in Seoul in South Korea.
Yes.
And then there was the question of the permission that he sought
Yes.
for medical treatment. Now, I'm not deliberately not referring to other incidents regarding alleged persecution
Yes.
of the family. But I'm referring to those 3 incidents which are admitted
Yes.
by
In
the
the-
applicant.
in
And
the-
the applicant, in fact, says that we intervened at the church and also with the soul thing because
Yes.
we had information that he was going to make political statements.
Yes.
And we didn't give him permission because to go for medical treatment because he didn't give details about his condition and why he wanted to go.
Yes.
So that is not in dispute.
Yes.
She says that on the basis of this deep-rooted differences and dissatisfaction,
Yes.
that the husband then made a deathbed declaration
Yes.
that he doesn't want the president involved.
Yes.
And even though we don't have to make pronouncements on those issues, it's not necessary. But she proffered those incidents
Yes.
in support of her assertion that we could never have agreed
Yes.
for the current president to be part of the funeral, and also gives, on her version at least, credence to the fact that the former president on his deathbed declared his
Yes.
unhappiness with the current president and said that he didn't want him involved.
Yes.
So all of that goes to the issue of whether in fact there was a meeting of the minds
Yes.
on this issue. So essentially say, but it may be so that you had in mind that the government now had in mind that the current president was going to be involved, but insofar as the family is concerned,
Yes.
we never intended that and we couldn't have agreed to it
Yes.
for these reasons. Now my question is, I'm sorry, it's a bit of a
Yes.
long explanation, but I had to do it because the question is that did the High Court engage with that argument at all?
No, they didn't. It's a little bit superficial because what they do, if you go to page 314, they first identify the issues to be decided before paragraph 18, and then they then deal with reason for decision at page 316. And then they say at paragraph 25, it is well established in our law that the correct judicial approach to the interpretation of written documents is that the inevitable point of departure is the language of the document itself. Words must be given their ordinary grammatical meaning unless to do so would result in absurdity. A written agreement between the parties must be read as a whole to determine the true intention of the parties. And then they say, if regard is held to the grammar and syntax of FAA 7, the purpose of which it was drawn up considering that both parties were alive to the disputes between them, FAA 7 can only be interpreted as an agreement between the parties. The agreement entailing first and foremost repatriation to Zambia for burial purposes, based upon the chronology of the common cause facts referring to the media briefing and the proposed program drafted by the family, fortifies this finding. There is thus no factual dispute between this court. The legal principle, pacta sunt servanda, agreements must be kept, also finds application. So, and then at paragraph 28, they say the agreement leaves no room for doubting that the current president of Zambia would be involved in receiving foreign dignitaries as head of state of the host country. Details as to who else was to speak other than the leader of the opposition party that the deceased belonged to are trivial. So that's how they deal with it. They never engaged with the primary dispute between the parties, which is we simply do not want the president of Zambia to play a role in the funeral. They classify that as a trivial dispute, but yet it was the central issue between the parties.
Just one last question, then I think my colleagues will...
Your 10 minutes will be over.
My 10 minutes will be over. Just one last question. Your answer to Justice Norman's question on the issue of the right to... Is the right of the right to a state funeral, is that a benefit?
Well, it's not clear in the Act that there is that benefit. When you look at the schedule, item 9 says funeral expenses.
Yes.
It doesn't say state funeral.
Yeah.
It says funeral expenses. So it means it could be a private funeral.
Yeah.
but paid for by the state.
But is it not so that in terms of this letter at page 128, whatever benefits there may have been were withdrawn?
Yes, they were
It
withdrawn.
doesn't only list the benefits. In fact, paragraph 5 says that with immediate effect by withdrawing all the benefits
Yes.
conferred on you by
Yes.
the Act.
Yes,
So anything that you would have entitled to is withdrawn now.
yes, it
So
was
at the
withdrawn.
time of his death,
Yes.
that is the
Yes.
the situation that pertained.
Yes. And you will see, Justice Smith, that in the pleadings now and then in the argument, they've changed that whole language. The letter from their client said, we're withdrawing everything. Now they say, no, this was a suspension. Suspension to be reinstated upon a corpse. It's a very absurd argument.
Yes, yes, thank you.
Yes.
Mr. Nkatoibi, oh, sorry.
Earlier in your address, you mentioned to the court that the High Court didn't have regard to the pleaded constitutional rights that you mentioned,
Yes.
dignity, family life, and equality.
Yes.
Isn't this dispute really not about those high mind issues, but about the animus between the president and the deceased? In that, on the papers, the family has no objection to a burial in Zambia. The family has no objection to a state funeral. The family's objection seems to me to be the presence of the current president. Isn't that really the dispute between the parties? And it's been clothed in this other attributes which the court is invited to consider in determining the issue.
Yes. What happened, Justice Moke, is that certainly by the 17th of June, at the time FAA 7 was drawn up, the parties had made a lot of progress in finding each other. And the issue that remained in dispute was the role of President Hichilema. Now, as soon as the government of Zambia reneged on that, the family's view totally changed. As we speak today, the family's view is that it is opposed to a state funeral, it wants a private burial. And at the time the matter went to court, there was no longer any agreement on a state funeral, and there was no longer any agreement on a repatriation. And of course, on the third issue of the role of President Hichilema, that's clear. So as matters stand right now, they don't want a state funeral, they don't want a repatriation. Their intention was to bury Mr. Lungu in Johannesburg.
Yes, but again, on the face of it, but for the participation by the current president, it seems to me that the body would have been repatriated.
Yes,
Because that's the only change.
Yes, it seems clear that you are correct that if nothing had changed by the 17th of June, because what had happened is that after the 17th, they said, but you are now reneging on the agreement, and therefore we're pulling out of it, which you are entitled to if there is an agreement. You are entitled to pull out if one party reneges. So the entire agreement was then torpedoed, if I can put it that way.
And then, how then is this court invited to make a determination as to, for example, the right to dignity being implicated, given that substantively the issue is about the participation and presence of the current president?
Now, let me put it this way, Justice Muge. If the Zambian government went to court and it tried to enforce a right, at that point in time, it was enforcing a right against the known wishes of the family. The question is, how should the court adjudicate that dispute? Because the order that it obtained does not require the consent of the family. In fact, the judgment itself expressly says, for as long as you are the president, you are a former president, based on the judgment of Kaunda, the state has an entitlement to the body of the president. That's the law right now, as expressed by that judgment. Now, that has nothing to do with contract. It has everything to do with public law. They say, as a matter of public law, the body of the former president is to be dictated upon by the government of Zambia. Now, if that is the approach of the Zambian government, how does that square up with our constitutional rights? So, at that point, as soon as they decided that they are no longer interpreting a contract, because the contract was always based on consensus between the parties, but as soon as they said, as a matter of law, the Zambian government is entitled to take the body against the wishes of the widow, then they had an obligation to weigh up the provisions of the Constitution. So that's how they are implicated.
Judge Keatley had a question.
Yes. Thank you, Mr. Nkatobi. I was going to ask you about it overlaps, the respondents' reliance on the Kaunda judgment and overlapping with that, their reliance, as I understand it, on custom and practice.
Yes.
We've talked about agreement and the act, but it does seem to me there was a third basis upon which they relied, which is custom and practice.
Yes.
And calling in aid the Kaunda judgment.
Yes.
Which was, I think the High Court adopted that almost holus bolus.
Yes.
Could you, have you anything, or
Yes.
what would you say about that line of causa?
Yes. Now, there are problems with the approach in the Kaunda judgment. I mean, just firstly on the fact, according to the affidavit given by Mr. Kaunda's son, he says what would have happened is that the body of President Kenneth Kaunda would have been buried at Heroes Acre. Thereafter, the family would be entitled to exhume the body and bury it wherever they wanted. But the family unilaterally decided that it was not going to exhume the body afterwards. But even then, you can see that it always remained the family's decision what to do with the body of the deceased. But there is a second problem, which is that the question as to whether the Kaunda judgment applies or does not apply depends on the resolution of the foreign law issue. And the foreign law issue under the Law of Evidence Amendment Act, it's called the law of a foreign state in that act, is a question of fact. Justice Smith knows a lot about application of foreign law. Is a question of fact. There is an affidavit prepared by the Attorney General who proclaims his expertise. We have no doubt about that he has expertise. But he is not an expert witness. He is a partisan applicant promoting the interests of the Zambian government. So they have a problem at the point of departure that they never established Zambian law under the Law of Evidence Amendment Act of 1988. They also have a third problem. If you are going to apply the law of a foreign state in South Africa, on Justice Unterhalter's judgment in MTN, the first question is it reconcilable and compatible with the South African Constitution? Now, that is the analysis that the High Court failed to conduct, because we would imagine that in South Africa, it ought to be reasonably clear that there is no state that can override the wishes of the widow in relation to the burial of their husband. And we would imagine that that proposition is protected by Section 14, by Section 10, and by Section 9 of the South African Constitution: equality, dignity, and family life. Now, those three defenses that were put by the widow were just never adjudicated by the court.
And, sorry, was there any, even just on the basis of assertion, was there any suggestion that there is some authority or some precedent in Zambian law which would apply to the facts of this particular case?
No, the only authority is Kaunda. That
The
was,
facts are different.
but the facts are materially different, yes.
There's never been on the papers a deceased president who was stripped of his benefits,
Yes,
who was prevented from exercising his rights to attend a religious gathering
yes,
or to associate,
yes,
and who clearly there was bad blood,
yes,
which is exactly what led to the family's and the deceased's wish.
yes, yes. Yes, that's what led to Mr. Lungu saying, I'm returning to politics because I can't tolerate what's going on to me.
Sorry, Mr. Pretoria, I was just following up on some of the questions. Just, if one accepts that the treatment that was visited upon the late president until the time that he sought treatment, medical treatment in South Africa, was really bad, if one accepts that, then one has to do another exercise, am I correct, of looking at what his wishes were.
Yes, yes.
We understand the wishes of the First Lady, that she wishes that the President be buried in South Africa.
Yes.
But I tried to find in the papers a place where the late President had indicated that he would like to be buried in South Africa. Because for me, that doesn't become reconcilable with what is contained for instance, just as maybe I mustn't load that question a lot, but for instance, if you look at what happened immediately after his death, his daughter, Ms. Tassila, addressed Zambians.
Yes.
She released a press statement addressing Zambians. All the statements that the late president has issued, and even his interviews, they emphasize his passion about his country.
Yes.
And we do not have anywhere in these papers where he had said, I would like to be buried in South Africa. Now, I'm trying to see how does one then balance these interests, bearing in mind that on the papers we have been told that at the time they were drafted, at least the family hadn't had regard to the president's will. So we don't know what his wishes are in terms of the will, what's contained in the will. But from the reading of these papers and the reading of how he expresses himself and how passionate he is about his country, he comes from Zambia, he's Zambian, he was in South Africa for a short period of time. His children grew up there, he has a home there. And if one has regard to all of that in looking at what is it that perhaps he would have wished for, because that's not contained in the papers, yes.
No, we accept that. Perhaps just to deal with what his wishes were.
Yes.
So we know that at page 187, paragraph 3.34. Yes, I think it's volume 2.
187.
Page 187, paragraph 3.34. Yes. Yes. So here it says, on 18 May 2025, the late President Lungu was interviewed by Dr. Sishua, a Zambia historian and a senior lecturer at Stellenbosch University, as part of the academic's research into the book that examines the presidency of the late former president. During their meeting, the late president, inter alia, highlighted his displeasure of the applicant, complained about his ill treatment to which his family is also subjected, and made it clear that he had told his family that were he to die, the applicant, that is the government of Zambia, would have no say in his burial. The two's meeting was widely publicized in the Zambian media after Dr. Sishua posted details of the meeting, including pictures of the two, on his social media page on 19 May 2025. These pictures were of appeal in Zambia because they were the first public images of the late former president since he left Zambia in January 2025. Then that's the interview with Dr. Seshua. Then the wife then says, I also spoke to him. He says, I personally spoke to the late President Lungu on the 3rd of June 2025 for the last time, shortly before he was sedated in order to insert a ventilator. Among other things, he complained about the ill treatment that the applicant had subjected to, repeated his wish that if he died, the applicant, that is the government, should be nowhere near his body or funeral, and stated that he had also shared this wish with the Zambian researcher, Dr. Seshua, when they met on 18 May 2025. This was a deeply traumatic experience, culminating in a painful farewell.
Now having regard to what my sister, Justice Norman, has summarized, clearly that was, I think, comprehensively, quite correctly set out by my sister. And that was the reason why initially
Yes.
the family was quite prepared for the body to be repatriated, taking into account all those factors that my sister has set out.
Yeah.
But the one thing that they were not prepared to compromise on, and which, as you have just pointed out now, the former president expressed
Yes.
on the verge of his passing on, was that he did not want the president, the current president, to be involved in the funeral. And that is where things broke down
Yes.
between the parties.
Yes.
But for that, the former president would be buried in Zambia, because clearly, all things being equal, that is his home. He was the president of that country, so one would accept that you'd wanted to be buried there.
Yes.
But this was a big problem for the family, not only for the family, but for him as well.
Yes. Yes, I think his wishes are clear. In fact, they are wider than I initially suggested, because I suggested that the problem was limited to the president. But what he says is that actually it's the government that I have a problem with. I don't want them to have a role at all. And then the family had managed to reach a mediated outcome, but it was violated by the Zambian government. The challenge...
sole reservation was his political foe. He didn't want his political foe to be anywhere or to be involved with his funeral. So, in examining the wishes of the dead, why can't it be concluded that he wished to be buried in Zambia with that one qualification?
It's not clear to me that we can make that assumption safely. I think we can say that he would have expected. Let me put it differently. I think that if he knew that the burial in Zambia means control of the funeral by the government, he would have said no. I think that's the fairest way of reading these papers. And that is, in fact, the biggest problem, is that right now, a burial in Zambia means the control of the funeral by the government. I think on that score, he would have said, no, I don't want to be buried in Zambia, if that's what it means.
Mr. Gauteng, can I just come in there? I think it's important we don't lose sight of what this case was initially about. It was based on the government's right
Yes,
to determine and to receive the body,
yes,
which puts it squarely in the realm, as you said, of public law.
yes, yes.
We're not really in a case of private individuals
Yes,
within South Africa
yes,
who, different factions of a family fighting over where a body should be buried and
Yes.
what the wishes were.
Yeah.
This case started as a government saying we have a right to determine. And then it also seems to me that it was impossible for, I think it would be, the family doesn't say that he wanted to be buried in South Africa.
Yes.
But on the fact, it seems to have become impossible for him to be buried in Zambia without the president's involvement. I mean, that's the government's stance, certainly in their replying affidavit.
Yes, that is also the outcome of the High Court that we are here about. The outcome of the High Court is that the government has a right to override the wishes of the widow where the deceased is a former president as a matter of public law. And that is why Kaunda is important. So what we want the Supreme Court of Appeal, what we ask of the Supreme Court of Appeal, is to overturn that principle as bad in law, that the government has no right to override the wishes of the widow in relation to the burial of their husband, regardless of the fact that the deceased is a former president. We say it is a terrible precedent that a widow can be dictated upon by a state about what should happen to their deceased husband. That's the issue that has to be overturned. What the outcome of that?
The end result would be it would be up to the family to decide whether to bury him in South Africa or Zambia.
Exactly. And there may be a different dispute, and that is Justice Keithley's problem among the family members, which is the usual case. Some family members may say it must be South Africa, others may say it must be Zambia. But the question of the autonomy of the widow is the principle that we are asking for from this court. It's the autonomy of the widow. And that autonomy of the widow has been completely obliterated by this judgment.
And I think the reason why the family has adopted this position should also be borne in mind.
Yes.
Because it cannot be said that those reasons are flimsy. They are not disputed.
Yes.
And at the very least, one can understand why the family is unhappy.
Yes.
Is that not so?
No, correct. And incidentally, it's also the reason why the former president was not happy.
Yes.
When he said, I don't want my government. Yes. It's an extraordinary thing to say, I don't want my government to have anything to do with my burial. It's truly extraordinary.
Yes. And this followed when, obviously, at the time when he was ill and later turned out gravely ill. Yes. When an application was made for him to travel to South Africa for treatment, there was a one-line, literally a one-line letter to say, regrettably, your request is denied. Yes. Well, the explanation for that was simply that he didn't provide details of his condition. Yes. So one can hardly say that the family and the late president didn't have reason to be unhappy.
Yes. Well, they now say that he traveled without permission. He had to. Yes. And everyone didn't know at the time that actually this was his last trip, because he never came back didn't come back at all. So that's Justice Morgan, just to come back to I think you started this part of the conversation. So the question around where should this body be buried is probably a secondary question. The primary question is really who decides. And here we know that the president didn't want the government to be involved. And we know on the fact that a burial in Zambia means controlled by the government. And that would be completely against the wishes of the deceased. And once you are in that zone, it is the widow who decides. And the widow is entitled to say, I actually want the body to be buried in Zambia. But that's not upon the wish of the government. It is upon the wish of the widow. That's the only principle we are asking for.
Can I just ask you, I think we're nearing, we still have some time, but I think you may be nearing your allocated 1 hour. Just on the question of the point that you took regarding the enforceability of an agreement over a corpse and the public the public interest considerations in that regard. You're still persisting with that argument?
Yes, if you come to the conclusion that there was a valid agreement concluded by Mr. Zulu, then you have a further challenge that you have to confront, which is it compatible with South African constitutional law, A, to contract over a corpse? I quoted Foot. It was my junior who found Foot. But anyway, we've got Foot as a reference. But Foot seems to have continued being the law in South Africa right up until now.
One of my colleagues used to say that once Foot is quoted, it shows a level of desperation.
The only defense we have is that...
Whether it's the right foot or
the only defense is that he seems to still be current. Yes. But the point about that issue is really that contracts over corpses are proscribed in South African common law, because a corpse is not a thing. It has no rights, it has no obligations. It is not regarded in the law of property as a thing. It's also not a commercial species, this thing called a corpse. It's bones of a deceased person who used to have rights, but they have no rights posthumously. And so this is why, for moral reason, contracts over corpses were proscribed. Now that obviously doesn't mean that you cannot contract over the service. You can contract over a service, but this was a contract over the actual corpse, and that contract would not be enforceable in South African law.
But I suppose that before you even get there, or before, as the High Court has done, went on an interpretive exercise, you need to pronounce on the question of whether there is a contract in the first place.
Yes.
And it seems as if the High Court didn't engage in that.
No. No, they never engaged, because the central point, the meeting of the minds, was the role of the Zambian government. They regarded that as trivial. They never engaged it. Yes.
But that, sorry, just to say that you make your submissions quite comprehensively regarding this issue.
Yes.
Of the enforceability of the agreement in your acts of argument.
Yes, we do.
I assume you stand by that.
No, we stand by those.
I think Judge Muki has got a question.
It seems to me that this particular aspect wasn't taken as a point in a High Court.
That's correct. That's correct.
How then do the appellants raise this in their appeal? Because in proceedings before the High Court, the parties joined issue, and the appellant did not say that, to the extent that the government claims a right reference to a contract, the law doesn't permit it. That wasn't pleaded.
No, that's correct. That wasn't pleaded. What is pleaded variously is how this contract is meant to be squared up against the Constitution.
That sounds entirely different from the point that one of the points that you are taking in this appeal.
Yes.
Because the constitutional point is a standalone point.
No, that's true. That's true. I don't have an answer to that question, to be frank. The fact is that it's not pleaded. If you are not going to invoke your rights under Section 39, that when you are interpreting any document, you have to do it through the prism of the Constitution. On this score about whether or not contracts are in conflict with the common law, then I can't run the argument. But I can run the argument only insofar as its compatibility with the Constitution. Justice Smith, thank you. I have nothing else to add.
Just find out maybe my questions.
Thank you.
Thank you.
Thank you.
Thank you for your submissions. Mr. Stoop, I think there's still 15 minutes before tea time, so you can. Your 10 minutes will start now, so you can expect questions after the expiry of the 10 minutes.
Thank you, Justice Presiding. It is quite correct that the respondent's case, I will also refer to the respondent as the government, concerning the clear right rests on two pillars. The first is a common law legal right to bury the late president, and then secondly, rights that flow from an agreement concluded between the government and the family. As far as the burial right is concerned, that right is grounded on custom in Zambia, in terms whereof presidents who passed on were all afforded and accorded a state funeral and a burial at Embassy Park. It's common cause on the papers that Embassy Park is a national heritage site. All Zambian former presidents, even two of those presidents who died abroad, were brought back, repatriated, and they were buried in Embassy Park. The right, and that is the common law right, that we say the applicant or the respondent relies on, is compatible with South African law in the sense that there is a development that is noticeable in our law as far as the burial right is concerned. And what we will argue is that initially the right of the heirs and the spouse trumped other competing rights. However, that's been changed, and currently what the courts are doing is to balance the rights. That is, the right of the heir and of the surviving spouse with competing rights, and to determine what is reasonable under the circumstances and who should have that right to bury. And in applying that balancing exercise, or conducting that balancing exercise, what must happen is that the court should apply the principle of Ubuntu. There is the matter referred to in the heads Alice versus RL, where the court, it's a decision of the Gauteng local division, Johannesburg, where the court clearly stated that if there are competing rights, what should happen is that considerations of public policy, the principle of fairness, equality, equity, the interests of justice, the balance of convenience, and the exigency caused by the deceased in this particular matter that I'm now referring to, being a public figure of national importance and was to be accorded a civil funeral by the provincial government were taken into consideration. And what we say is that this approach is perfectly compatible with the rights in the Constitution. In other words, that a court should balance the interests. But in addition to that, what the government relies on is an agreement concluded between the government and the family. And that agreement, which the court, held was expressed in the form of FAA 7, we will argue was an agreement freely and voluntarily entered into and remains binding on the parties. My learned friend referred to a confusion on the part of the quota quo in its application of foreign law. And we will submit that the High Court did not err for two reasons. Firstly, when it concerns the burial right, what the court was enjoined to do was to find the applicable lex causa. And in the case of a burial right, what the court had to do was to look at the connecting factors, which it did, and based on that came to the conclusion that the applicable law would be Zambian law. Now, in the case of contract, different considerations arise. In the case of a contract concluded by foreigners, such as in the present case Zambian citizens and the government, that is a peregrinus, what the court will look at is the lex loci contractus, in other words, the law where the contract was concluded. Justices, we provided you with additional authorities, a number of additional authorities. I will refer to those authorities in due course. But what should also be considered in this particular case, where the repatriation, in terms of the agreement, was to have taken place in South Africa for purposes of a state funeral in Zambia. In other words, performance is transnational. It's not only in South Africa. What should happen now? And we will refer you to the MTN decision. It is quoted in my learned friend's heads, and we also gave notice that we will refer to that matter, is that the court should consider what would have been, or there are three rules that the SCA laid down in that matter, and one of the rules or approaches is that you should consider what would have been the dominant performance in terms of the contract. And we will argue that the dominant performance was the repatriation that took place in South Africa, or had to take place in South Africa, and on that basis, and based on it's the language that Foot was well versed in, the lex loci solutionis. In other words, the place where performance would have or ought to take place was South Africa. And that would lead to a conclusion that South African law would apply or should apply when it comes to the interpretation of the contract. And that takes me to the agreement. Context, Justices, as you know, is all important. And the context is to be found in the number of engagements or the meetings that were held between the government and the family. And I just briefly need to go to those. It is in the supplementary founding affidavit, paragraph 7, on page 55. These were all high-level meetings. The meeting held on 6 June 2025, The Zambian delegation was led by the Minister of Foreign Affairs, and the details of that meeting is given in paragraph 7.2 onwards. Mr. Makebe Zulu, who constantly acted as spokesperson for the family, was also present.
Sorry,
And
Mr. Sue, what was that page number?
it is page 55. This is where the details of the meeting of 6 June started. And
sorry, Mr. Stupid, your 10 minutes is expired, but I think what we will do, since we are close out, you may proceed for the next 5 minutes uninterrupted, and then we'll put questions to you after tea.
thank you, Justice Presiding. In that meeting, what is important is that the family, when the government proposed that the body should be repatriated for purposes of a state funeral, the family objected, and that is in paragraph 7.6. What they said is no, the President's wishes before he died were, and importantly what they say is that his remains should be repatriated back to Zambia in the same manner that he had travelled to South Africa. 2, his body should lay in state. And then 3, in the event that he was accorded a state funeral, his successor should not be allowed to attend it. Now this is important because what happened thereafter, there was a further meeting. Again, a high-level meeting, and this time the delegation was led by no one other than the former Vice President of Zambia, and he was accompanied by the former Secretary of Cabinet, and there was also the current and former Secretary to the Cabinet, and then also a senior chief. And there were certain agreements that were reached. These are set out in paragraph 7.10. I need not take you to what was agreed there. And then importantly, on the 14th of June, there was the final meeting. Well, just take a step back, Justices, I apologize, on that page, previous page, it's paragraph 7.10.6. What was agreed that a tentative order of events or a program be drawn and shared with the family. And what happened is that the government then did draft or provide a program to the family, but that was rejected. And the family then provided FAA 7 to the government. And it is that document, that program, that was subsequently agreed upon. And that takes me to the press conferences. And the press conferences are important. Those transcripts are annexed, and I just need to take you to the FAA 9. If you could turn the page to volume 1, page 94. Now, if you look at those who participated in that presentation or that broadcast, firstly, there's a TV presenter, then there's Mr. Kavindele, the Vice President of Zambia, there was the Secretary of Cabinet, there was the Minister of Foreign Affairs, and then Mr. Makebe Zulu is the spokesperson for the family. If you turn the page on 95, Mr. Ziligone, who is the presenter, he then confirms there was a handshake symbolizing the beginning of closure. A bit down the line, there is what he says is Secretary to the Cabinet, Patrick Kangwa, announced in South Africa during a press briefing with the family Representative Makebi Zulu that government and Mr. Lungu's family had reached an agreement on how the former president's funeral will proceed. And then the Secretary to Cabinet confirmed that. He said, now in accordance with the family's wishes and the dignity befitting the service of the sixth president to our nation, a state funeral shall be presided over by the President of the Republic of Zambia, Mr. Hakainde Hichilema, culminating in the former president's burial on Monday, 23rd June 2025. Mr. Zulu never objects to this. He doesn't contradict it. He's present. He confirms it. If you go to page 97, still in that press conference, Mr. Ziligone, that's the presenter of the interview, family spokesperson Makebi Zulu expressed satisfaction with the outcome of the negotiation with the government. And then Mr. Zulu starts talking. And he then thanked everyone for their participation and for what they managed to achieve. The Minister of Foreign Affairs, down the page, he then also said, we continue to thank the government of South Africa. We'll be requesting officially that the late Republican President of Zambia be given full military honors here as the body departs on Wednesday. The Vice President then ultimately also confirmed that certain matters can be addressed, and he would like to believe it's well that we've reached agreement. You've heard from both Secretary to Cabinet and the other party. Those are the points that we've agreed upon. So what the parties are quite clear about is that there was a meeting of minds, the matter is settled. If you then look at Mr. Zulu's Facebook video, this is the document that, or the transcript that my learned friend took you to. On page 101, Mr. Zulu then explained, he gave the context, he gave the background that you find on page 101, and then important on page 102. What Mr. Zulu says is that the late president's specific wishes and those of the family are as follows, and he lists it then. The third point, he says, thirdly, in the event that he was accorded a state funeral, his successor should not be allowed to attend it. But then importantly, at the bottom of that page, what Mr. Zulu says is the following. He says, but there is a compromise. This is what the late president wanted, but we reached an agreement with the government, finding common ground. He says, following the former president's death, the family has been engaged in protracted negotiations with the Hichilema administration, which it requested to guarantee that the wishes of the former president will be honored. The negotiations were never about pending matters in court relating to any of the members of the family or associates of the former president. If you then go down the page to the bottom, opposite line 19, the two parties have since agreed to honoring the following undertakings, with each party giving and taking, so that we could come to a common compromise. And the following has been the compromise. And justices, if you read through that compromise, nowhere is it stated that the current president may not attend and may not be present when the state funeral takes place. And this is what the High Court, in its judgment, also recorded. So the common compromise, as Mr. Zulu termed it, was the result of a give and take, an agreement freely reached.
I think it's maybe a convenient time for us to take.
May it please you, Justice Presiding.
Inconvenient, 20 past. Court adjourned until 20 past. Mr. Stoop, as I said, your 10-minute immunity is unfortunately over and you can expect questions. Can I just ask you one thing before my colleagues? The argument regarding the right of the Zambian government, which is founded in the Benefits Act, that argument, you're still persisting with that, or is it abandoned? Or?
Justices, the right is not founded in the Benefit Act. The Benefit Act provides context.
Yes.
It provides for a suspension of the benefits under circumstances where a former president engages in active politics. But such a decision by a former president would not result in a disqualification, which the Benefits Act also provides for.
Yes.
So the benefits are suspended.
Yeah. No, I just want to know if you're still persisting with the argument that you're making in your heads of argument. That
Yes, the Benefits Act is not the basis for
yes.
the right, for
No,
the burial
that.
right. That is based on custom.
Yes, I think
So
my
that
sister has
means-
questions
yes,
for you.
That means custom and then separately the agreement
Yes,
that you say.
yes.
I understand that you accept that South African law should apply to the contract. Was I correct in that?
On
Did
the
I
basis,
understand you correct?
on
So
the
you're
basis,
also no longer contending that Zambian law should apply across the board to everything?
what we contend is that should Zambian law apply across the board, the result will be the same. But properly applying the principles, the conflict of law principles, in respect of the contract, it may lead to the conclusion that South African law must apply based on the fact that the lex loci contractus rule applies in our law, and read with that, you should consider where performance will take place. That is the lex loci solutionis rule. And what the appellate division has stated in the Freuchen case, the Freuchen matter, is that where the lex loci solutionis differs from the lex loci contractus, the former will prevail. So if performance...
Just come again with that submission.
So where the law of the where the place where the performance will be rendered differs from the place where the contract was concluded, the former shall prevail. That is in the Freuchen matter. It is the decision of the appellate division, 1924 AD 171. Justices, these four matters were, that is my understanding and instruction, were conveyed to you yesterday. And there should be a bundle that ought to have made its way to your desks. And I apologize if it may cause inconvenience. In the Freuchen matter, that is what the court stated.
Mr. Stewart, could I just ask, your voice is quite soft and the acoustics here are very bad.
I apologize.
Could ask you, just for myself, my fellow panel members might hear you well. But
I certainly apologize for that.
no, there's no need
Justice
to
Kessler.
apologize. You weren't the architect of this building. On the right to bury, there you rely on Zambian customary law.
Yes,
Correct.
yes,
Initially.
yes.
Yes.
And what we say...
And so you say that regardless of your causa based on contract, when it comes to customary law, a different system of law should apply.
In the case of the
Customary,
burial right,
yes.
Zambian law should apply.
Yes.
Because that law has the closest connection to the parties in the matter, all being Peregrini, all being Zambians, including the first respondent, the government.
Well, I think that question remains open. I won't debate it with you. I just wanted to make sure that... I wanted to ask you, where is the expert evidence on Zambian customary law?
The reference is to the Kaweche Kaunda matter.
Well, that's just it's a decision of a court.
It is.
But with custom, one needs more, doesn't one, than simply one case which isn't on par with this one, in the sense that, as I understand from the Kaunda matter, this wasn't someone who had been stripped of benefits and who'd made a very express wish about not where to be buried but how.
Yes.
So where is apart from the Kaunda case, where is your expert evidence on Zambian customary law?
Yes. What the Attorney General says, he sets out his experience. No. Yes.
So are you relying on the Attorney General?
Well, what he says is, look at what happened in the history of Zambia. He provides that in paragraph 12.20. He refers to the agreement concluded that there should be repatriation and a state funeral. And he then continues. It appears from the fact that all of Zambia's foreign heads of state are now deceased, and in accordance with the applicant's established customs and protocols, each was buried at Embassy Park.
Yes, but where do we have the evidence of what the protocols and customs were? You know, I would have expected that we would have had somebody steeped in not diplomatic affairs, but affairs of state, to say, you know, these are the protocols. And then that there would have been someone other than the person litigating on behalf of the government telling us what the customs were. Yes. It's not enough to say they were buried in accordance with the customs. We need to know what those customs and protocols are. So where is the evidence of that?
The AG has it on the high authority of the High Court in the Kaweche Kaunda matter.
So you rely effectively solely on the Kaunda matter for evidence of the customs and practices.
And in addition,
is that correct?
Indeed, Justice Ketley. And in addition, with what in fact has happened historically.
Well,
these two.
Yes, but all that he says is that they were buried in accordance with customs and protocols, but we don't know what those are. That's my point.
Well, what the AG does is he refers to the High Court decision. I will take you to that decision. But what the AG says...
Sorry, just before you get there, just on my sisters, you see, the fact that former presidents were buried in a certain way is neither here nor there. The issue is whether or not there has been a dispute about who has got the right to bury. And what my sister says, that under those circumstances, when there's going to be a pronouncement regarding that issue, that is when the law, whether customary law or statutory law, comes into play. But one cannot use the historical fact of burials which happened without any conflict between the parties as proof of custom.
Yes, that is why the AG refers to this decision, because what the court in that decision set out is exactly what he says are the Zambian customs and protocols. What the judge in that matter said, and it is quoted in the founding affidavit, state funeral is a public funeral ceremony observing the strict rule of protocol held to honor people of national significance. Even if it was a personal wish of the late president not to be accorded a state funeral, such wish must be overridden by public interest.
But where does the judgment say what the protocols are?
Well, the judgment you will find in the first application brought. It's in volume 1, page 29, And
Sorry, please lift your voice, Mr. Stroop. 29, did you say?
29.
Yes.
I think,
That's where the
Mr.
judgment
Stoop,
starts.
it happens when you are stooping.
Yes.
Yeah. So
It's probably a birth defect, Justice Smith. But I will try to speak up.
yes.
So what the court in that matter dealt with is almost identical to what is currently before you. There was a wish on the part of the late President Kaunda to be buried next to his wife on his farm. And the question is, or was, should that wish prevail? And the court said no. First, starting with the wish of the deceased. And what is also important and significant is that at that time, the former President Lungu was then the current president. He dealt with this issue. And it is during his tenure that this decision came, subordinating the wishes of a late president to the public good and the right of the government to bury in Embassy Park. In the judgment, it is on page 33 of the record. The judge recorded the wish of the deceased was even made available to the cabinet during his lifetime, and the correspondence aforementioned, according to the applicant, will be made available after discovery. So it was publicly made known by the late President Kaunda. He does not want to be buried in Embassy Park. The family then applied the court, and their case is that their late father's wish should be honored. There's a letter quoted by the judge, it's on page 35. We, the children, grandchildren, and great-grandchildren, are grateful to the state and the President, His Excellency Dr. Edgar Chagwa Lungu, for according the first President of the Republic a state funeral. I'm summarizing. But then they continue and say, but no thank you, we do not want this. And the judge then had to deal with that dispute. And the court found that because the late President was a person of national significance, the wish of the family will be or must yield. And what the court found is, that is on page 36 of the record. A state funeral, in my firm understanding, is a public funeral ceremony observing the strict rules of protocol held to honor people of national significance. That is what we say.
I understand that reasoning. I'm not saying that it was right or wrong, but I understand the reasoning based on the facts of that case. Because essentially what you had is a former president who had not been stripped. So it's not only the salary or financial benefits, because former presidents have officers, they have staff, they are in fact still performing some function. So there's some status beyond the emoluments or financial benefits that attach to it.
Yes.
And for that reason, I can understand why the court said, but you've got all these benefits, you're in fact still almost not employed by the state, but there were certain responsibilities that you had to the people of Zambia. But this is not the position here. This man was stripped of everything. There's nothing. His office was taken away, not performing any function, and he had been treated as such, as if he is a person that had been stripped. So who is to say what that court would have found on the basis of these facts?
Justice Presiding, the court clearly did not consider or concern itself with that question. But what is important is that the late President Lungu chose to go back to active politics. The Benefits Act provides for that. He may do it. If he does that, he doesn't lose his status as a former president. He does not, because of that, no longer have national significance. Should he die?
Well, what did he have at the time of his death? Other than the government's, as you say, entitlement to say that, well, we are going to bury you now. What else did he have? What was left of his presidency? And regardless of the fact whether it was a suspension, although the letter, page 128, clearly says that his benefits, everything has been withdrawn, the fact of the matter, at the time, he was not considered to be entitled to those benefits.
Indeed.
The only thing that remained is for the government saying, well, despite the wishes of the family, we're entitled to bury you, and on the basis of the Kaunda case, those wishes must be overridden. Despite his wish, and despite the fact that he had been stripped of all his... That is essentially the case that you're making out.
That is Justice Smith. But the important point is that the decision to engage to become engaged in active politics, he could have obviously disassociated himself again and said, I will no longer involve myself. And what the government says, what the Attorney General says, is the moment that happens, the benefits would have been restored.
Yeah,
that could have happened.
Yeah, it could have, but the fact of the matter is that it didn't happen. Yes. And at the time, he was not, in terms of the act, whatever benefits would have accrued on his widow upon his death didn't accrue, or she was not entitled to it because he was not entitled to those benefits at the time of his death.
Yes. What the government says is that following his passing on, obviously the impediment to the payment of the benefits fell away, and the funeral benefits and the benefits that accrued to his widow, she's entitled to a house, she's entitled to a vehicle, those benefits will now again be payable. Yes. This is what the government says.
Yes. Thank you, I understand that.
And
Sorry, carry on.
Yes, what the Attorney General says is that this is how that law is applied in Zambia, and that brings me to the question of foreign law.
No, sorry, I had a question.
Yeah, just Justice Keatley, and then Justice Muki, then we'll allow you to put your question.
I just wanted, it was my final sort of prefatory question, which was, do you dispute that our Constitution applies in this case, or do you accept that it applies?
I accept that.
Thank you.
I accept that. I will deal with that.
You don't have to deal with it now, yes. Or whenever it suits you, but yes, I've been answered.
How it will impact on the burial right.
Yes, thank you. Justice Muki?
You referenced the decision in Kaunda in the context of answering the question about custom, reliance on custom. It seems to me that in fact wasn't the issue that was before that court. As I read the judgment, and in Zambia, that is the initial step or the initial proceeding that has to be instituted in review proceedings. So the court initially determines whether or not full review proceedings be instituted. So the decision was in that context. That's one observation. And related to that is that it seems to me that what the court said about burials in that decision was an original statement, in the sense of the court doesn't reference any authority or any prior decisions as to the burial of former heads of state. And all of this in the context of the question about what is the basis for this custom which you invoke.
Yes. I can't take it beyond the page. What the AG says is that there is the customs and the protocols. The judgment confirms that protocols will apply. That judgment creates a precedent. That precedent is binding on the family. And that is the government's case.
Yes, thank you. Thank you.
If I may just take a step back and deal with the agreement and conclude by just referring you to that last press conference, because it is important just to understand the position of the parties immediately following the conclusion of FAA 7, and then I will step on and focus on the alleged breach. And I will argue that the family's contention that this agreement was breached is entirely ill-conceived.
Sorry, you dropped, is entirely?
Ill-conceived.
Ill-conceived, thank you.
The last media briefing or news broadcast, yes, media briefing, it's FAA 11.
Sorry, page?
109, volume 1.
Thank you, Mr. Sir.
Now, again, what is important is who were present during that broadcast. You'll find that on page 109. Firstly, the presenter, then again the Vice President, Mr. Kavindele, Patrick Kangwa, the Secretary of Cabinet, Mr. Haimbe, the Minister of Foreign Affairs, and importantly, Mr. Zulu. It starts on the next page with a summary by the presenter, and importantly, if you then look at what the Secretary of Cabinet says. We wish to confirm that the arrangements for the repatriation and burial of our late sixth President, His Excellency Mr. Edgar Chagwa Lungu, who passed away on that date at Mediclinic in Pretoria, have been concluded. Then importantly, now in accordance with the family's wishes and the dignity befitting the service of the sixth President to our nation, a state funeral shall be held and shall be presided over by the President of the Republic of Zambia, Mr. Haikande Hichilema, culminating in the former President's burial on Monday. The President of the Republic of Zambia, Mr. Haikande Hichilema, has officially extended the mourning period by 9 days from today, and then the dates are given. Immediately thereafter follows Mr. Zulu. He says, the family of the former President, Lungu, who passed away in South Africa on 5th of June 2025, wishes to announce that it has reached agreement with representatives of the government on the repatriation of the remains.
What page are we on? I was on 95, which I think is correct.
Page 110.
110, 110.
Sorry. No wonder.
110, and I'm
Okay.
on the next page, 111.
Yes, 11. I thought you were dealing with FA9. Thank you.
Yes, with representatives on the
That's
repatriation
fine.
of the remains. And then this follows the resolution of the impasse that had caused disagreement between the two parties, and then he thanks other parties. He then also, again, but down the line on that page, carries on and he expresses his sincere thanks for all involved. And what is important, Justices, is that Mr. Zulu is it's common cause that he's the spokesperson of the family. And this has never been repudiated by the family. What they say, with reference to these press conferences, is The family conveyed publicly that FAA 7 should be implemented. That's their comment. On page 112, there is a contribution by Senior Chief Mumbi, and he says, we're happy that ultimately the country, the different functions that were there have now held hands. They've come together as one so that we together move forward and see that our son is buried with the respect and dignity that he so much deserves. And then Bishop Banda, and you will remember that he's specifically mentioning FAA 7, he says, this has been a very, very difficult phase, and it has been a joy to see what God has done today, to see the family and the government team in a joint press briefing presenting to the nation the fact that even though there were some hurdles, these hurdles have been overcome. That speaks of who we are. So, what we say is that compromise that Mr. Zulu said was reached, and which the High Court said or found was recorded in FAA 7, formed a binding agreement.
Are you saying Mr. Zulu was the agent of the family?
He was the spokesperson.
I know. Are you saying that in contract law he was the agent?
Well, what he conveyed was the family's appreciation and acceptance
was he
of...
acting as agent for the family? I think your point is that the family has never said he wasn't. Is that...
That must be the case, Justice Cashley. He spoke on their behalf. He acted on their behalf. And if you then look at FAA 7, what is significant is that FAA 7 does not refer or does not in terms refer to the current president. Nowhere does it do that. It's on page 92. Program for repatriation, I'm not going to read the entire document. But on the Wednesday, the 18th of June, there's the arrival of the body and there will be military honors. And what the government says is because there will be military honors, the current president as commander-in-chief will be present. It follows from that very basic fact.
So it wasn't stated the current president's involved, but you say that it must be read into. But was the government at the time aware of the family's wishes that and the former president's declaration, deathbed declaration, that the current president should not be involved in his funeral?
Justice Presiding, that context is given by the previous meetings.
Yes.
Because in those meetings, it was stated that the current president may be present. He may be present where foreign dignitaries are or are involved. And then there will be a decision on who may speak.
Yes. But what I'm saying is that on the basis of that context that preceded this, what you call to be the agreement.
The
compromise. It can be, it's equally reasonable to interpret that as the government not saying anything about the presence of the current president, and it was accepted that he is not going to be there. Because if he doesn't say anything, then it can be both ways. It can go both ways. Is that not so?
Justice Presiding, that's why the context is important. Yes. And that context is given by the prior meetings. That context is also given by the press briefing, because this court has found that how the parties interpreted and implemented an agreement is part of the context. And how they understood that agreement clearly appears from the press briefing, where Mr. Zulu, in so many words, let me put it differently, when it was pertinently stated that the current president will be present, he does not contradict it. Why not? Because that's the agreement. There will be military honors. And the context of that military honors is given in those two prior meetings.
Mr. Stu, what is one to make of what the appellants say in their answering affidavit? Have regard to paragraph 24.2 on page 206, which reads as follows: it's denied that the current president would preside over the state funeral, and then continues, it was proposed that the current president only be allowed to receive foreign dignitaries and to be present at the funeral where foreign heads of state would be present. The current president was not to play any further role in the burial proceedings. I understand this to be what the family's attitude was,
Yes.
insofar as the presence and the role of the president, that he will be there, but he will not preside, and that he will keep the company of other foreign heads of state.
Justice Mookie, that statement, that denial is denied by the press conferences and what the parties expressly stated there. But what is meant by the words, it is denied that the current president would preside over the state funeral? What they say is he may be present. This is where they say it. He will be allowed to receive foreign dignitaries. He could be present at the funeral where foreign heads of state would be present. So his presence there, would that mean he will also preside? Fact of the matter is he may be there. He has a role that he will play. It's agreed that there will be military honors. This appears from the papers. So the denial that he may not preside, what we say is that the High Court could safely reject this denial as inherently implausible.
Is the legal position regarding this not the following? The family consistently deny ever having agreed to the role of the current president. They say that that was not the intention, they didn't agree on that. Now, that could be a factual dispute where Prescon Evans would apply, and obviously one will have to look at it, and we know what the law says, under what circumstances that factual averment can be rejected, if it is untrustworthy, and all those things that we know in the Zuma case.
Yes.
Was set out. But it's essentially an exercise that the court will have to go to. And you say that the High Court was correct within the context that you just painted now to come to the conclusion that it can safely reject the family's assertions regarding that issue.
Just a presiding guest. May I demonstrate why I make that submission? On that very same page, the family deals with the proposed program attached as Annexure FAA7. It's yes. Paragraph 25.2. They say, that document was in fact drawn up by the family and not the applicant.
Yes.
It was given to the applicant at the meeting. And then if you turn the page, 207, paragraph 26.1. The parties agreed upon the implementation of FAA 7. There's no dispute about that. That's what the
Yeah, but FAA 7 doesn't, we know that it doesn't say anything about the role.
Yes.
At least explicitly about
Yes.
the role. You trying to read into
I
the word.
will get to that because
Yeah.
that's tied up with the breach, Justice
Yes.
Presiding. And then in the next paragraph, 27, the speaker did outline a road map based on FAA 7. Now, what is that answer in response to? And that is in response to where the government deals with the press releases. So what the government says, look at the press releases, what was said there. The family does not dispute it. What they say is, yes, that is how we agreed. FAA 7 will be implemented, which we submit is permissible context.
But that's, I think the point is that FAA 7 doesn't expressly include the President.
No.
Your case regarding FAA 7 is that it must be implied that the family knew that military honours would have to include the President.
Yes.
So, and that's your
Yes.
case there.
Yes.
I think that's
Yes.
it. What,
And
if context is important, what then do we make of the fact that on the 18th of June, there were 2 programs sent to the family, and the second one, which in the answering affidavit precipitated the family's decision not to proceed with the repatriation, was the second one. It appears on 265 and 266. It specifically includes the President.
Yes. That,
And they say that was what precipitated their.
yes.
I mean that if context is important, that is a context that aligns with their version of what was agreed.
It demonstrates the family's breach of the agreement that was reached. Why do we say that? If you look at that second final program, what it provides for, what they say is that this program also outlines the involvement of the current president contrary to what was agreed. Now we know that FAA 7 does not state that the current president may not be present. FAA 7, in context, provides for the presence of the current president as confirmed by the family. They said he may be there. It provides for military honors. That context you have in the press releases. And if you then, with that, look at the second final program and the contention of the family that there was a breach, you will see that what is in the second program never exceeds or is contrary or flies in the face of what the family had agreed upon. Because what that second program provides for, firstly, the arrival of the current president, 1350. He will be there prior to the mortal remains arriving. Thereafter, the mortal remains will arrive, 1410 to 1420. Then there will be a church service. And it is this church service that the family says that was never agreed upon. And that's why we can turn our backs on the agreement. It's got nothing to do with the president. Then, after the church service, the body is taken away to the residence of the late president. Now remember, Justices, now the body is away. The current president continues to be present. And you will recall that the late president's wish was that if I'm there and I'm given a state funeral, the current president can't be near. What this document confirms is this is exactly what will happen. The body leaves, and then at 1450, the current president proceeds to the saluting dais, takes the president's salute, and then he departs. On no construction of this document we submit was there a breach. Not on what was agreed, most definitely not. So what we say is that that agreement that the government concluded and that the government undertook and on the papers affirmed its commitment to was never breached in the manner that the family alleged. And that's why we say that agreement, this is where the right that the High Court found existed is grounded in. That will take me to the conflict of law issue.
Sorry, before you move to that issue, when you put it, it appears to be quite simple, that one would have to put in the program, in brackets, the body leaves and now enters the new president. Then in that way, they know that by the time the body was there, the current president was not there. And then once the body leaves, then the current president then takes over. But then
I probably then did not express myself
yes.
Adequately. Where the program now specifically talks about the role that the current president will play.
Yes.
At that point in time, the body is already left. That's the.
And does the program show that?
It says that. It is on page 267.
Page 267.
267 of the record.
Sorry, just a minute, please.
Middle of the page. Well, perhaps it's better to start at the top. This is now the program, 1400 hours there, the body arrives. Now, in terms of this program, the dignitaries will already be present. On the previous page, 266, 1300 hours, there the program starts. And you will recall, Justice Norman, that the family specifically stated that we have no objection if the current president is present when foreign dignitaries arrive.
Yes.
This is what will happen here. It goes down the page, and then if you turn at 2 o'clock, 1400 hours, then there is the special aircraft that arrives carrying the body. 1410, the carrying party, firing party, pallbearers march to the foot of the special aircraft. 1420, the body of the late president is removed from the special aircraft, put on the gun carriage. 1430, there's the church service. I apologize. And then after the church service, the body is removed. And then 1450, there is the presidential salute.
All right.
Yes.
So, Justices, what we say is that the family contends that there was a breach. What we say is there was in fact no breach. And what the government is entitled to do is to insist upon compliance with the agreement.
Perhaps that would be a good time to address the constitutional issue.
The fact that the family concluded an agreement providing for the burial of the late president in the manner that they did certainly can't defend against the Constitution. A party who has the right to bury may authorize another person to do so, especially under circumstances such as this.
Would that party have the right to withdraw that authorization? And say, well, we don't want to proceed with this, we want to bury our family member in a particular way?
Justice Presiding, in the context of an agreement, if that was a term that consent may be revoked freely, that should be honoured. That's not the case of the family. It's never a term of that agreement that the family may unilaterally renege on.
Well, let's look, because you're basing this purely on a contractual issue. You're saying that the family reneged on the agreement.
Indeed.
So there's a breach of the family, and so you are asking for specific performance. That is essentially the case. So does a court have a discretion with regard to specific performance in certain contractual situation?
That is the law, Justice Presiding.
Yes. So can the court, for example, say that in this case, even though there's been a breach, specific performance would not be the appropriate remedy for the following reasons? And I think we have gone through the reasons before.
Yes. Justice Presiding, I will concede that.
Yes.
If that case was properly pleaded, but the case of the family is not.
No, but it is. I mean, the family has given extensive reasons why it does not want the burial to proceed on the basis. Those facts are there. And we'll hear Mr. Nkatobi as to whether or not that argument can be advanced. But the facts are there, and it's a discretion of this court, and we need to exercise that discretion in the judicious manner. And there may well be circumstances where that is not raised, where the court would feel that under these circumstances it is not appropriate to order specific performance.
Yes.
So, but we'll hear Mr. Nkatobi on that. But I understand your argument. Your argument is that the case has not been pleaded, yes, and that therefore, on the basis of the pleaded case, you are entitled to the order, which is in effect specific performance. I understand that argument.
The family's pleaded case is that the government reneged on the agreement. It breached the agreement. That leads us to the next question. Was that breach material? If so, clearly the family would have been in a position to cancel and to say we are no longer prepared to honour. What the government says is we did not breach, and with respect I demonstrated that the government's correct. And if there is a breach, that breach was not material. And what the family clearly ought to have done was to put the government on terms, to write a letter, for example, stating, this is what you plan to do, please confirm that you will not or refrain from doing it. They could not simply unilaterally have cancelled in the manner that they did, because this is effectively what they did.
Mr. Stoop, I just was looking at your amended notice of motion. We're in the contractual realm at the moment. And your notice of motion asks for a declarator that your client is entitled to repatriate the body for purposes of a state funeral and burial.
Yes.
If you are essentially asking for specific performance, then presumably you would have to ask for relief that accorded with the agreement that you are relying on.
Yes.
This goes wider than that. Would you
With
agree?
respect, not.
Well,
not
it says
the
a
case.
state funeral. It doesn't say a state funeral in accordance with the agreement reached by the parties, etc.
Just carefully, what FAA 7 clearly contemplates: a military honours, the body.
Sorry?
There's a state
Yes,
funeral.
but it was according to a specific program. You are asking for simply a state funeral. And that's why the negotiations ensued. It was how to accommodate your government's wish, your client, the government's wish, for a state funeral where the president would have play a normal role, and the family's wish for that not to be the case. And the relief you seek, if you are relying on an agreement, then, and if we were to find that the agreement is enforceable, then in fact your relief would be limited to what you say was agreed between the two parties. Not to a state funeral, because that would probably, in all likelihood, be presided over by the president.
Justice Casey, if that is the case, the applicant, the respondent, would be entitled to seek an amendment to the notice of motion, specifically limiting the purpose of the repatriation to implement FAA 7.
Can an officer of state, other than the president, preside, as it were, at a state funeral in Zambia? For example, the vice president.
On the papers, I can see no reason why that cannot be the case.
But how does the family enforce that? Because once the body is beyond the borders of jurisdiction of this court, the family has no recourse. They can't, I mean, how do they hold the government in the respondents in contempt?
They will be fully entitled to enforce the agreement in the High Court of Zambia, because it is an agreement that will afford them the right to insist that FAA 7 be complied with, and a court in Zambia clearly.
And there would then be more delay. And then we get to dignity and Ubuntu, which, if you look at Makanyane, recognizes the the respect to be accorded to individuals within Ubuntu.
Yes. That is a valid concern, Justice Kessler. And I can't speculate, but clearly what may happen is that if there is a breach, the family will have the right to enforce the agreement. They clearly will have the right to do that on an urgent basis, as what happened in the Kaunda case. There it was also on an extremely urgent basis that the court had to deal with this wish of the family to have the body buried.
Yeah, Mr. Stoop, you are nearing the end of your allocated time. I just want to, I think, Justice Norman, did you have a question or
No.
not? You're fine. Yes, proceed with it, please.
Mr. Stoops, I understood one of your earlier submissions to be that you are not invoking the Benefits Act as such as the basis for the relief, but that would be at odds with the case as pleaded. For example, in dealing with the particular right which the government is enforcing, that right is referenced to the Benefits Act. You mentioned, for example, is it 12.2 or 12.2 and 12.3 of the supplementary founding affidavit? Right. In paragraph 14.1 of the supplementary founding affidavit, there you crystallize the right that's been invoked. And then you reference back to paragraphs 12.2 and 12.3.
Yes.
Both paragraphs are in relation to the Benefits Act in the context of the clear right, which the government says is a basis for the relief that they seek. But in your submission, I understand you to say to the court that actually you are not putting much store on the Benefits Act.
Yes, that is correct, Justice Moki. The Benefit Act is referred to. I explained it on the basis as it provides context for the conduct of the government.
But it wasn't in the pleadings, it's not referenced as dealing with matters of context. It's referenced as dealing with the very substance which underlies the claim. And so that's your pleaded case.
Justice Moki, if that submission, which it's clearly, but it is in the founding papers, is not upheld, then it's simply something, it's like a plus particular. It's for the court to decide of the Benefit Act.
Then you're only left with the agreement.
So then it goes back to the Kaunda matter, where the court laid down a binding precedent that late presidents,
Yes.
the wishes of the family will yield. That is what the government needs to fall
Yes.
back on, and will fall, and in fact does do.
Yes.
Does fall back.
Yes. And then the agreement,
And
of course.
Yes.
Yes.
Thank you.
Do you have other submissions to make, Mr. Stoop?
I just need to briefly take you to the South African law of burial.
The
It's in
South
the
African
hands-
law of?
Burial.
Oh, yes, thank you.
What appears from the South African law is that there's been a development, and I will just briefly take you through that. The first matter in the heads is the matter of Prolog versus Du Plessis, where the learned judge pointed out that there's a difference between the approach of the courts in the former province of Transvaal and in the Cape.
I'm sorry,
where
Mr. Stoop, you're reading from your heads? Which page?
It's I will take it to that.
Yes. You must just, Mr. Stoop, when you make your submissions regarding this issue, just remember that I hail from that part of the country where
Yes.
where the courts have established a clear hierarchy of rights in burial. And I'm not sure if that issue has been the extent to which you can go beyond the wishes of the family or the heir on those other grounds that you mentioned.
Yes.
Has been tested against a constitutional inquiry or scrutiny, rather.
Yes, I will briefly develop the argument
yes.
to deal with that, Justice Presiding. It is on page 28 of the heads, Justice Norman.
Sorry, page?
28.
28, thank you.
28 of the heads, of the respondents' heads. It starts in paragraph 6.8, where it is pointed out that fairness should be a determining factor, where there are competing rights. And the next matter that I refer to is Finley versus Kutuane.
Was that where a family was involved, I'm assuming?
Yes.
Trollope versus Duplessis. That
yes.
was an,
these matters
I presume it was an sort of familial
yes.
private law.
Correct. Then there's the matter of Wellen versus Silwana. In the heads, it's referred to as W versus S. This is a matter from the Cape High Court, where the court pointed out that, and in the heads I refer to that on page 30. The learned judge stated that this is evidenced by the fact that over years there's been a shift from the blanket approach originating from the Roman Dutch principle that the heir has the right to decide on the issue of burial of the deceased. This is the right that the first respondent relied on in this matter. This approach did not take into account the expectations of the community, the relationship between the deceased while still alive, and this heir who has a right to decide the issue of burial of the deceased, and fairness and reasonableness of the decision. So that point that the judge might resubmit is important. In other words, that the strict adherence to the wish of the expressed in the Roman Dutch law, that the heir's wish will always take precedent, should be tempered. In Limaku, that's another judgment that I refer to, the court also approved that. And then in the next matter, and that is an important matter because in this case there was a conflict between the wishes of the family and the provincial government, who wanted to afford the deceased a public funeral. And it is in that context that the court, in that matter, and you will find the reference to Ubuntu, specifically in paragraph 39 of the reported decision. There, the learned
Mr.
judge...
Stroop, could I ask you, in this case, I have to confess I haven't read this judgment in full. In this case, was it just the widow who wished for a different burial? Or had the deceased... Was there any wish expressed by the deceased in that case?
Justice Kessley, I can
also don't
check.
know.
I did not.
Okay,
I did not pick that up. The wish of the deceased does not feature.
Okay, it doesn't. Okay.
Not how I recall the evidence. It was purely the fact that the family wanted a burial at a different location, and the question then arose: but what about the public funeral that was at that stage almost in the process of starting? And the learned judge there found that considerations of public policy, the principle of fairness, equality, equity, the interest of justice, the balance of convenience, and the exigency caused by the deceased being a public figure of national importance played a role. And for that reason, the wish of the family had to yield before the wish of provincial government. And we say that that accords with the constitutional imperative to approach the matter through the prism of Ubuntu. Because if Ubuntu is applied, the rights of the parties should be balanced.
I would have thought that Ubuntu in that context would first and foremost take into account the interests of the family, of a grieving family who wants to bury their loved one in a particular way. That must also be an important consideration.
Absolutely correct,
the application
Justice.
of Ubuntu.
Absolutely correct, Justice Presiding.
Was this also an inter-family fight?
This was a dispute between the family and the provincial government.
Why wasn't the provincial government then cited? I see it's LS versus RL. It's a strange way of citing a provincial government.
The head note does not indicate if the provincial government was in fact before court. I can't pick that up.
From this, I mean, we will check, but it does seem from the citation that it might have been two factions of a family, one of which wanted customary and a private burial, and the other who wanted him to, or her to be accorded.
That may be the way in which it played out.
Yeah.
Members of the family wanted
Yes.
the public funeral, and others.
Yeah,
may
I'm
have
assuming that's the case, but we will check.
Yes. Okay.
I see there are only two sets of attorneys as well, so it would appear as if those were the only parties to the matter, Justice Kathleen.
Do you have further submissions, Mr. Stoop?
Those are the submissions, just to emphasize that the application of the principle of Ubuntu, Justice Presiding, as you pointed out, clearly the wishes of the family must be considered and will be a factor. But then public interest, and in the specific case facts of this matter, the agreement that was concluded, and the fact that the deceased was a person of national significance. These factors should all be considered. That is what Ubuntu enjoins you to do. And what we say is that if you look at the agreement that was concluded, the terms thereof, the fact that the government did not breach those terms, that in terms of the principle of Ubuntu will lead to only one conclusion, and that is that the family's wish should yield to the common good. In the papers, what the Attorney General states is that the late President's grave has already been prepared. The entire Zambian nation was in mourning, in waiting. And it is that expectation that the family shattered. That is what Ubuntu will not allow. And that's why we say, if you apply those principles in terms of the South African law of burial, the result can only be that this appeal cannot succeed. And it should be dismissed with costs to counsel on scale C. May it please you.
We don't do scales in this court.
It will apply.
The scales of justice don't reach that far.
It will apply. It will apply lower down.
And if of course, if you are successful, then the order must then be amended in accordance with your amended notice of motion.
I will seek that relief. It must be.
Yes.
Just one question on costs. Why would you insist on costs if the appeal is not successful?
If the appeal
Because if the appeal is not successful,
Well, it should be dismissed, and the respondent should, as the successful party, should be compensated with costs.
Why? Because what the appellants are doing is to enforce their rights, and this is the family of the president, it's against the government. Why must they be ordered to pay costs even if they are not successful?
Justice Norman, the government will leave that to the court. It is a principle that should be honoured as far as costs are concerned. I will not persist with that.
Yes.
Thank you, Mr. Stoop. Mr. Mukatobi, reply.
Justice Smith, I only have 3 things to say to the court. And it's only just to clarify some facts, because there were some errors that we picked up that might creep into the judgment. The first one is, and all of them relate to this issue of the agreement. So the first one is at page 206, paragraph 24.2. My learned friend, I hope I'm not misrepresenting what he said, says that this paragraph 24.2 is proof of the agreement about the role to be played by the President of Zambia in the funeral, as per the version of my clients. But if that is what he said, he is wrong, because if you look at this actual sentence, it says it is denied that the current president would preside over the state funeral. Then it says it was proposed that the current president only be allowed to receive foreign dignitaries and could be present at the funeral where foreign heads of state would be present. The current president was not to play any further role in the burial proceedings. So it was proposed. There is nothing here that says it was agreed at the meeting. It was proposed. So you cannot convert now this statement to say this was an agreement. So to the extent that he suggested that this is an agreement, it's born of a misreading of the sentence. The next correction is actually it's in the same page. Around Annexure FAA 7, he also suggested that Annexure FAA 7, on our own version, is the agreement, but that's a misreading of paragraph 25.1 of the answering affidavit. 25.2 says, the proposed program attached as Annexure FAA 7 was in fact drawn up by the family and not the applicant. This program was given to the applicant at the meeting by the 7th respondent. So they draw it up, they give it to them. Let's see what happens next. The program shows that the current president was not to play any role in the burial. And if you turn the page, a handwritten program, this is now the response of the Zambian government. A handwritten program was in fact prepared by the Zambian Secretary to Cabinet, Patrick Kangwa, and given to the 7th respondent during this meeting. A copy of the handwritten program is attached here to marked Annexure EL16. Now, if you go to EL16, it's one of the programs I referenced in my opening address, which has not been answered. So EL16 is at page 256, and the typed up version is at 258. So if you go to 258, you look under serial 2, you see the Zambian government inserted under A, the president of Zambia. So in that meeting, 2 programs were generated. Program 1 was FAA 7, program 2 was EL16. FAA 7 was generated by the family, EL16 was generated by the government of Zambia. And that is why then 25.5 in the answering affidavit, it says, the handwritten program sets out the involvement of the current president in the proceedings, to which the respondents never agreed. 25.6, it is therefore clear that there was no agreement reached and the applicant is being dishonest in the representation of the facts to the above honorable court. So that's what happens in that meeting that is referenced at paragraph 25.1, 25.2, 25.3. My clients give the government their program, the government responds to this program. Now everyone knows the law of contract. I give you the program, you accept it with your own amendments, that does not amount to an agreement, which is what happened in that meeting. Now later on, and that's again another correction I need to make, later on what then happens is this, later on then further programs are then exchanged. The first program is at EL17. The next program is EL17. Because now there's a stalemate between the parties. We gave them their program, they gave us their program, we cannot agree. Then an attempt to compromise is at 261 to 262. That's now on the 18th of June, on a date different to the date that is at EL16. 261.
So is that page 2? Is that page 261?
261, yes. That's now another program from the Zambian government. Now that is referenced in the answering affidavit to make that clear. That's referenced in the answering affidavit at paragraph 29.2. Actually, perhaps I should start at 29.1, which is page 209. It says, the family did not renege on the agreement, the applicants did. Contrary to what was agreed upon, the applicant provided a final version of the funeral program to the family late in the evening of the 17th of June 2025, the day before the family and the remains were to leave for Zambia. A copy of this program is attached marked EL17. Now you go to EL17 at page 260, and the program is at 261 and 262. So that's the next program that is developed. Now, they say this program is contrary, the pleading says, this program is contrary to what was agreed upon and announced in the joint press briefing of the 15th of June. It, however, stipulates the involvement of the current president against the wishes of the late President Lungu and provides for the body of the late President Lungu being taken to a designated place for a short church service, all of which were never agreed upon by the family in any discussions whatsoever. And then finally, the next program, this is now the final program, is EL19. Now this is what broke the proverbial camel's back. It's EL19. Now you see EL19 is referenced at paragraph 29.4 at page 209. It says, shortly thereafter, the respondents received another program purporting to be the final program at 2300 hours in the evening of the 17th of June. A copy of this second final program is attached marked EL19. Again, this program outlines the involvement of the current president contrary to what was agreed. And when you look at 266, what it provides for at 10 to 2 is the arrival of Mr. Hakainde Hichilema. He stays in the funeral, and at 14:20, the body arrives of Mr. Lungu. Mr. Hichilema lives, if you go to 266, only at 1500 hours. So he arrives at 1350, the body arrives, he stays there, the body leaves at 1430, so for 40 minutes, he is in the same room with the body. And then he leaves at 3 o'clock. This is what the family then says, but once we saw this, we saw red, because this is not what we understood was going on. Why on earth would they be exchanging these programs if on their version by FAA7 they had reached an agreement? We've got 4 programs in total. And now then, the last thing, in addition to the evidence that there is clearly no agreement between the parties, is that what we then see is that the next thing they do at 269, so once they receive that program, that last program, which shows that the president arrives, the body arrives, it stays for 40 minutes, the president leaves, is then at EL20 at page 269, on the 18th of June 2025. Now at 11 o'clock they've received that final program. Then they say, notice of decision. this is now my client, Esther Lungu. Notice of decision to bury the mortal remains of the 6th Republican President of Zambia in South Africa. Please take notice that the family of the 6th Republican President of Zambia, Dr. Edgar Chagwa Lungu, has decided to bury his mortal remains here in South Africa. Burial arrangements are underway and the family will notify you as soon as the said arrangements are finalized. And that's when they have now decided we can't go on with this. Now, my learned friend has placed considerable reliance on the transcripts, but there are massive problems with these transcripts. I'm sorry to say, but you have to take them with a pinch of salt. The first problem, if you go to there are 3 transcripts. Now, the version of the respondents is that there was only 1 press conference. There were not 3 press conferences, only 1. It was held on the 15th of June, 1 press conference. It was thereafter broadcast in different news outlets. One is Zambia TV, which is at FAA 9. And then another one is by a different news outlet called Zanis, which is at FAA 11. But
sorry, what was the first one? What page?
The first one is page 94.
Thank you. And the next one?
The next one is page 109.
Thank you.
Yes. But they are recording the same press conference. But this order and the sequence of the speakers is different. So you look at the first one at page 95. What you find there, you find Mr. Kangwa speaks after Mr. Ziligone at page 95. And I just want to show the court the problems with this. So if you look at page 95, where Mr. Kangwa speaks, he says, now, page 95, after line 17, now in accordance with the family's wishes and the dignity befitting the service of the 6th President to our nation, a state funeral shall be held and shall be presided over by the President of the Republic of Zambia, Mr. Hakainde Hichilema, culminating in the former President's burial on Monday, 23rd June 2025. Now, you go then to page 110, which is now a different news outlet. Those exact words appear at page 110 at line, I think it's 14. Now, in accordance with the family's wishes and the dignity befitting the service of the 6th President of our nation, a state funeral shall be held and shall be presided over by the President of the Republic of Zambia, Mr. Hakainde Hichilema, culminating in the former President's burial on Monday, 23rd June 2025. The exact words. Even the next sentence, the President of the Republic of Zambia, Mr. Hakainde Hichilema, has officially extended the mourning period by 9 days from today, the 15th June 2025, to 23rd June 2025, the day of the burial. Again, that is at 95 to 96. You go to 110, those exact words are there. But at page 96, look at the next speaker who speaks at page 96. It's Mr. Ziligone. At page 110, look at the next speaker is Mr. Zulu. The family of the former president, this is now according to Mr. Zulu, who passed away, wishes to announce that it has reached an agreement with the representatives of the government on the repatriation of the remains of the late former president, as well as his funeral and burial program. Now, those exact words, you know where they come from? They come from page 101, which is FAA 10. At line 7, the family of the former president, which is the second paragraph, the family of the former president, Edgar Chagwa Lungu, who passed away in South Africa on the 5th of June, wishes to announce that it has reached agreement with the representatives of the government on the repatriation of the remains of the late former president, as well as his funeral and burial program. Now, that is what is taken from that and then inserted after Mr. Kangwa. When you actually read it, you are of the impression that this was one speaker speaking, another one responding. But when you actually deconstruct it, what you find is that they firstly created the impression that it's 3 different press conferences from one conference, and then they've rearranged the words of the speakers. And when you read the words of the speakers, you get the impression that it's completely out of context. Now, this is why the family, in the answering affidavit, denies FAA 9 and FAA 11 and says the only press conference that is true is FAA 10. Now, you will find the express denial in the answering affidavit at page 207 to 208. So where you see there, paragraph 27.2, again it is evident that the applicant is attempting to mislead the above honorable court. Annexure FAA 9, FAA 10, and FAA 11 indicates that the 7th respondent conveyed the agreement as outlined in Annexure FAA 7 to the applicant. The funeral would not be presided over by the current president. Look at what they say next. Annexure FAA 10 is a transcript of a press briefing given by the 7th respondent, that's Mr. Zulu, on behalf of the widow, and correctly outlined the correct factual position at that stage, namely, and then it records what the correct agreement was. So you have a sharp dispute of fact, and when you actually try to reconcile the version of the applicants, you find incongruities that are impossible to explain. And I don't want to make accusations, but I invite the court to read those 3 transcripts. It's utterly astonishing what they did.
But sorry, just what do you then say if you say that 1110 is the correct agreement?
Yes.
What do you say about Mr. Stoops' argument regarding from line 12 up to line 20, and then Mr. Zulu's confirmation that in fact was the agreement?
Sorry, my lord.
Mr. Stoop referred in particular to that paragraph in the middle of the page that begins with "now in accordance with the family's wishes."
That is what is taken from FAA 10 and then inserted under the wording coming from the Zambian Secretary of State to create the impression that the Zambian Secretary of State spoke and then there was confirmation.
Oh, I see. This is FAA 11.
Yes,
not
yes,
FAA 10.
exactly.
I see.
That's FAA 11. So FAA 9 and FAA 11 are the disputed ones in the answering affidavit. Yes. And where there's an accusation of an attempt to mislead. Yes. Now, if you just do this coldly on your own, you just look at what they say, and you can see the rearrangement, where one speaker speaks, the same words appear on 3 different occasions, FAA 9, FAA 10, and FAA 11, and you're trying to work out how did this happen. And so FAA 9 and FAA 11 are disputed as an attempt to mislead. FAA 10 is confirmed by the family. And now when you look at FAA 10, family is clear on this. It's totally consistent with what they've always said, which is, we told you first we don't want the president of Zambia to speak, and then secondly, we gave you a program which does not include the president of Zambia. Now, so the answering affidavit specifically accuses the Zambian government of attempting to mislead. And you can deconstruct the misleading by just reading the transcript, and it becomes so evident there that there is in fact some validity in what the family was saying.
Yes.
So ultimately, what you are left with something worse than attempting to mislead when you actually try to work out who said what it was, because it makes utterly no sense to rely on those 2 transcripts. And FAA 10 makes a lot of sense because it is compatible. I mean, otherwise it stands out as an outlier in the context of what the position of the family has always been. Because it only makes sense that the position of the family before, during, and after was always that in accordance with the wishes of our father, the government of Zambia should not play any role. And it's also consistent with the programs, the fact that there were 4 different programs, some including the president, others excluding the president. It would make no sense to go to a press conference and contradict everything that had gone before, and then contradict it later, and then attempt not to implement the agreement. It would just make no sense. The only thing that makes sense is that FAA 10 is what was agreed, and the program at EL 19 reneged because it then superimposed the president as a central player.
And your argument is that the mere fact that there were these conflicting programs flying around attests to the fact that there was no agreement in FAA 7 as alleged by the government. Is that your submission?
Yes, FAA 7 is a proposal. It's responded to by EL 16. In EL 16, the government makes it clear that we want the president to be there. You cannot give FAA 7, which excludes the president. And then EL 18 and 19 are the 2 additional programs. Again, those programs, one includes the president, the other excludes the president. All of that are completely against the notion that there was a meeting of the minds about the role of the president. So you cannot even rely on this alleged agreement. That's really the truth. You cannot rely on this alleged agreement. So what you are really left with, you are left with a public law argument, which is based on custom. Because now the Benefits Act has been abandoned for the first time here. It has never been abandoned before, but today it has been abandoned. So you're left with a contract, but the contract is highly dubious on plus one evidence. Then you are left with the custom. But the ultimate end of the custom is the counter judgment. But there, then you have a problem that Zambian law was never proven.
Yes.
Thank you.
Thank you, Mr. Ndokatobi. Mr. Stu?
There were serious allegations made.
You want another bite of the cherry?
Not really. This is not on the papers, yes, that these transcripts were falsified. I just need to point out what is in the record. Paragraph 9 on page 61. I'm quoting from the record. On 19 June...
Page 61.
61,
yes.
Volume 1. On 15 June 2025, at the Rivonia Southern Sun Hotel, during a joint briefing, designated speakers representing the applicant and the family addressed media houses from Zambia, in brackets, Zambia National Broadcasting Corporation, Smart Eagles, Grandstone Television and Zambia National Information Services. The speakers outlined the roadmap which made it clear that all subscribed to what was agreed during the meeting on 14 June 2025. Then they provide the transcript of the briefing given to the FAA 9, that is the one by ZNBC.
Yeah.
They also give Mr. Zulu's video, and they also give the next one is the Zanus News briefing. These were different interviewers. The names of the interviewers are specified.
Yeah. Mr. Stoop, we will look
So
at that and we'll take account of that, but I don't want you to re-argue the case now. But we've taken cognizance of your submission and we've got those references. We shall consider it. Thank you. Thank you. It then only remains to thank Council for the comprehensive aids and authorities, the bundles of authorities that were presided. Those were very helpful to, and also in the manner in which the matter was argued. We appreciate the fact that the matter remains urgent, despite the fact that it's almost a year now since the former president has passed away. But there are important issues involved in this matter, and we need to give proper consideration to those and to the submissions and arguments that were advanced today. But having said that, we realize and appreciate that there is a need for us to hand down our judgment urgently and as soon as reasonably possible. So you can rest assured that that is what we are going to do. But then on that note, judgment is reserved and the parties will be informed when it will be delivered, and council must travel safely back to your respective homes. Thank you. Thank you. Court will adjourn. Kira toto